lectures that are encapsulated in the since the publication of TRRC's report. And we're using this to say itself. It's not until when an institution like CRC is established. It's a continuing process. And it is important that we should, or the responsibility of the moderator of a particular section, which is the most important one. However, I will use this singular honor to introduce the moderator, who will then use that time, okay, with the program manager of activist staff and the final year law student in Mr. Sherman. Thank you all for your time.
Welcome to this session. So this lecture has been going for some time, it's been serious, and so we have done a couple of these areas with regards to the transitional justice process. And today we're talking about accountability. And this is a particularly most of the students because you are in the transitional justice group. The last time we were here, I did share that I did a research paper for the National Endowment for Democracy on accountability mechanisms for transitional justice processes. It was a comparative paper looking at Yugoslavia, Rwanda, and South Africa in comparison to what we have in the Gambia right now. And I shared the paper, so I'm hoping you read it so that you will have questions for them. Right? But also cares about us students beyond the classroom. He is one. Next to Mr. Tal, we have Ida Person. Ida Person is the special advisor on transitional justice to the Minister of Justice at the Ministry of Justice. I have known Ida for a while during its time. And next to me, and here, since we have only one lady on the high table, and since we have, I went through the draft legislation for the creation of the extraordinary chambers for West Africa for the Gambia. That is the legislation that is supposed to create the hybrid court. Can you take us through how far we have come? And
thank you. So I'll speak both in English and TRC unit of the Ministry of Justice. A lot of people then believe that I sort of just work for the Ministry of Justice, but it's important to know that the post-TRC unit is for the whole government. TRRCB 263 recommendations laying job government being a government be first na ini will implement. 263 recommendations are to be implemented. And yes, many of those recommendations have to do with justice and accountability, conciliation. So really, recommendations in TRRCB, they're really extensive, they're really broad. The 59 government institutions, and civil society, nyoko wara implement. Wow. Government be not fast na ini, nedineng implement recommendations here within 5 years. People explain ne dune bena ministry, mosi wara gis bopam or nyari ministry. This is going to take us 1 year or 2 years, and it's not going to be a cheap endeavor. Overall, Transitional Justice Program is a really broad one, and it's a really undo, right? The government in the white paper responded to that to say that, wait, this is prosecutions under transitional justice. It's not our usual prosecutions. In fact, there are some crimes that may have happened here that even in the Gambia, our usual systems, they are not adequate. Basically, amna yena crimes yi nga xamne duñ crime Gambia ñom in enforced disappearance, torture, duñ mëna dem ci court bi because duñ mëna éga fofu nonu sax. So fokk ñu create something li nga xamne dafa special, li nga xamne dina mëna gis crimes yu xewon yépp Gambia. And that's how we came up with the terminology, the Special Accountability Mechanism, SAM, SAM. So Special Accountability Mechanism, it's a concept of that. Special Prosecutor's Office. Special Prosecutor's Office, their role is going to be to investigate and to build cases, post-TRRC cases. Because the TRRC do on court. Ku ñëw, ku bëgg nga ñëw, mun nga wax lu la ne, xam nga, du woon court du dee demee noonu xaw ma yan ñaata musa dem court fii nekk fi witness and so on di nga gis ne fa completely different rules yi dañ different so special prosecutor's office bi dafa war a jël information ba la TRRC bi collect mu door di ko investigate pour pareyaas case yi pour ñu mun a dem court different process la different methodologies lañ dee use so loolu mooy liggéeyi special prosecutor's office bi su passé special prosecutor's office bi soo bildee sa case ba pare foog nga am fi nga yóbbu sa case yi foog nga dem court léegi si SAM bi there's two basically adjudication forums, two courts that are envisaged. There's the Special Criminal Division of the High Court, which has already been established. It's a domestic court. It's a division within our court that's already been established. There we can immediately take cases of murder. Murder is a crime that we recognize in the Gambia, kidnapping, assault, and you name it. But some of the crimes, some of the charges are going to be possibly international crimes. Enforced disappearance, like we were saying, torture, and crimes against humanity. And for that, building a SAM, I like to think about it like a triangle. It has three corners: Special Prosecutor's Office, Special Criminal Division of the High Court, and Special Tribunal. Special, because of what we're doing. Now we can delve deeper into each of those components. What is the special prosecutor? What are the powers? When is it going to start, etc., etc. Same for the special criminal division, and we can also discuss the special tribunal. Is that fine to set the stage?
That is fine for a baseline.
Okay, thank you.
Fine for a baseline. Thank you very much, Jojo. It's good to know that we are on forward. Sal, I want to come to you. My question is going to come from, similar to this, it's going to come from what Ida has said. Especially on the timeline. Ida did say that it's a little ambitious. I'm saying implementing the recommendations within 5 years. For me, so Sal, I want you to take us through whether it is possible to do this within 5 years, particularly on the accountability. I'm taking reference here because the ICTY was established in '93 and it was dissolved in 2017. That's over 20 years, right? The ICTR for Rwanda was '94 and it was dissolved in 2015. So looking at those timelines with regards to prosecution, now I do know they had more people to prosecute. They had a longer list of people recommended for prosecution than Gambia does have. But do you think with what we have, Ida is saying we have a budget, a proposed budget of $150 million to make this happen. Do you think, even with this money available, do you think we can meet the deadline?
It's an honor to really sit on this platform to discuss a topic that's very close to my heart. Kontaan naa trop pour topic bi waxtaan bu am solo boo xam ne ñun ñëpp te bépp am nañ si interest daal. First of all, I think to clarify, I did not see that money is available.
Yeah.
That's the money loolu lañ soxla.
Yes.
Loolu lañ soxla. We need to distinguish what we need, number one, and secondly, that money is required for the entire PJ, not only prosecutions. So that we differentiate, reparations and institutional reforms and so on and so forth. I have to, I need to focus on where I'm more criminal accountability. I cannot speak to the broader aspect of it. I think either it's a better place to speak about whether or not the timeline is ambitious. But I believe very detailed steps to get there. And I believe that in as much as it's ambitious, it might be ambitious, but it has to be, and I think it's achievable. Once the resources are available, and I think there's already commitment to make it happen. In terms of the court, establishment of the accountability mechanism, which Ida has already, this famous triangle, the SAM, we are already, as you know, we've already passed. And then we agree, big, xam ne wax ne lii moo fi xew comme ni ko Aïda waxee loolu du woon call loolu dañu doon waxtaane pour report li xew ñu bari ñëw ma def léeg-léeg lañ def sama mbokka bésoon loolu nguur bi ñu def accept recommendation bi daanaka yëpp recommendation bi mooy si wàccam bi si bu ñu tàmbalee loolu nguur bi ne léegi am na ñoo xam ne foog ñu yóbbu leen fu mu xanaa yaa ngi tooñ ñi ba pare du mën a tooñ ñi ba dara du si gën a daal pour à part comme dampal xool d'accord ne dañu am pour set up système boo xam ne dañ mun a ñi nga xam ne ñoo tooñ Gambien si bëree bëri ak moom Gambien dañu mun a aate te si aate boobu dafa am maanaam boo xam ne dañu ko mën a aate si Gambien système bi dafa comme ay da waxee Gambien système bi alaaw na fu ñu def loolu am na yoo xam ne tamit dafa crime bi dafa serious ba nga xam ne dañ leen di ooy personal crime yi ne crime yooyu anywhere ba koo commit am na si yëpp Second World War ñu doon bokk ba tey foo ko defee muy torture muy enforce disappearance muy sexual gender based violence and yooyu crime yooyu dañ ko ñaaw ba nga xam ne even am na suñu loi yoo xam ne xëy na torture ak assault du benn xam nga bu nga yóbbu ni nga yóbbu ko nga fekkas ba torture dafa nekk loo xam ne dañ ko ñaawal tout like crime against humanity loo xam ne da crime boo xam ne da nga ko commit ñu ko def ndax ñëpp ñu war seet xam so like in terms of jumtuwaay yu nguur bi jël kon naa fi nekk ni suñ néegi député yi ñoom war a di paas nañ ñaari loos yoo xam ne mooy special accountability mechanism ak special prosecutor's office pour taxawal office boo xam ne dina vérifier kayit yi pour because when it comes to transitional justice process dafa war a fair nekkul ne da ngaa junjee nit rek nga jël yóbbu foog mu jaar foog mu am due process foog mu am yoon kuñ tooñ kuñ wax ne moo dafa def dara foog nga jox ko ak yàlla xam moom noo ko ne moom even ku ñëw indi perpetrator bi accused bi ko victime bi at the same time justice foog nga boole si due process even ñi nga xam ne ñu indi dañu war a am seen ñu leen taxawal dañ leen war a météo ne ñun seen axa yëpp jaar la nga xam ne soo aatee dafa nekk lu fair te loolu dafaa jël time investigation dafaa jël time so fu mu nekk nii in terms of timelines I think force nga wax yëpp you're talking about duration bu mu jël pour complete but I think Gambia ñun in terms of setting up I think so far our timeline is very much the processes I'm opportune and privileged to be part of the committee because ñu ngi draft the statute for the proposed hybrid court and war a liggéey boobu sori na su jógee Gambia dina dem ECOWAS su soobee yàlla ECOWAS tamit suñ ko xoolee ñu ak d'accord ñu ñëwaat indi ko suñ léegi député bi so fan naa ne daal fii su nekk nii top legal framework bi foog ma ne dina jël time yu bëri fan naa li li am solo mooy xëy na kookar bi ñu xaalis bi ñu soxla boobu gën a nekk challenge waaye pour taxawal yes fanaa démba lañ am executive order from their president's office démba after 20 years ñun already ñun li xewoon fii from 2017 to now we already taxawal nañ ay loi kon naa in terms of time Gambia ñun already we are moving very very fast dafa li tamit jaar nañ si dëkk yu bari parce que ñun suñu procès bi ñun dañ ko moom ñun dem ñoo ko moom dañ ko moomal Gambia ba pare jël victime bi def ko si digga si centre bi ba pare make sure ne ñoo ko moom waaye tamit ñu liggéey ñi nga xam ne am nañ si xarañ nañ si fu nekka jël nañ ñi gën a xarañ si lii muy Gambia ñaaka Gambie yëpp ñëw nañ pour ñu liggéey système boo xam ne ànd nañ si nañ ko seetal soobee jërëjëf
Sall jërëjëf wax boobu am na solo trop so dama bëgg a ñëw si Samba. Look, the reason we set up this entire mechanism, that is the Samba we are talking about, all of these institutions, the reason we're talking about accountability is because there are victims, it's because something wrong happened and it happened to a certain number of people that need accountability. And what role do they have to play? Now, I have gone through draft legislation for the creation of the hybrid court, and I know it talks about victim participation in it. But I want Sam to take us through victim participation and the significance of it. And I mean not just as witnesses testifying through the trials, but their overall participation within the accountability process.
Thank you very much, and good morning to everyone. I see a lot of victims, part of the audience. I know your ears are open, which will require that I expand on. As the former two speakers have spoken, I'm sure they have enlightened us on the various issues which they have talked on. Now, when we talk about victims, there are two categories of victims. We have direct victims and indirect victims. Unfortunately, the direct victims may not. Some victims became aware of the fact that their family members were actually disappeared, and the various processes that went through, but it doesn't even end there. What happens to the perpetrators of this for them, and what happens to those who have suffered as a consequence of this crime? Maybe one of the loved ones that were disappeared was they don't have food to eat. These are issues that have come up. So these victims, are they able to have some sort of compensation as a consequence, which trickled down to their livelihoods and affect and impacted their lives very, very seriously? So, apart from testifying, as the moderator has indicated, victim participation in the whole process is very to assist the victim to come to terms with what actually happened, to accept it and to move on. Their participation is very, very important, because at the end of the day, we need to move past this phase. We will never, ever have peace of mind. For example, if you had someone that just got up one day and left the house and never came back, and you will never sleep if you don't know what happened to that person. You might be feeling that the person is still alive somewhere, or the person abandoned the family. You may have so many thoughts in your mind that are going to continuously cause you depression. You'll be traumatized. But the moment you know that the person lost his life and was buried, you have peace of mind to know that the person is no longer available. And the person did not desert the family, the person did not abandon the family. So victim participation is very important also in the sense that it helps the government to understand that they have been able to reach out to the people most affected and to assist them to overcome the situation which they are facing. It's not only about victims. It also involves the perpetrators. Unfortunately, I would have a little diversion here to talk about the perpetrators. The perpetrators also have rights. Notwithstanding that there have been recommendations for prosecution, those offenses or crimes need to be proved beyond reasonable doubt. And the rights of the alleged perpetrators must be respected. Those rights are provided for in the Constitution. Of the Prohibition of Torture Act 2023, the offense of torture was not existent in the Gambia. That's very true to an extent. To the extent that actually Section 21 of the Constitution of the Gambia in 1997 that talked about torture by defining what torture entails and what will constitute torture to become a crime. That notwithstanding, the Gambia is party to a lot of international covenants and instruments, particularly the African Charter on Human Rights, that clearly has defined what torture is and the guiding principles which have been developed. Which means in the absence of legislation in the Gambia, the courts could make resort to international instruments that they have ratified, and therefore had the possibility of charging someone with torture. But we thank God now we have the Torture Act, which unfortunately is not retroactive, which means it cannot be visited to the offenses that took place before the Act came into existence in 2000. I'm from Nala, and the role that Nala plays in the administration of justice, and which Nala will play in the administration of justice when it comes to the prosecution of these offenses under the TR here. Any other legislation, including the legislation that has been passed now, must conform with the Constitution, which is the grand norm of the Gambia, for us to provide them with legal representation. And that is where NALA comes in. Whole transitional justice process, something which has been pushed to the back burner. NALA has not been taken into consideration in all the aspects. But I'm wondering, if I may ask, whether NALA has been particularly invited for tribunal that will be critical. Judges have been trained because there are new offenses for which they are not particularly versed with, and for them to sit on those cases, they need to. Same is with the Ministry of Justice, the Special Prosecution Department, and those who consider some of these offenses. The question I'm asking, has NALA, that has issues of justice, the members of the bench, and NALA. I'm talking about a program, a training designed for NALA as defense counsels, officer in NALA. So the rest can even appear before the. And now, if they are not specifically trained on these special offenses, do they have the capacity to be able to defend perpetrators or alleged perpetrators of these offenses? I think I'll end here. Thank you very much, and we can have more on this and enlighten ourselves further. Thank you.
Thank you very much. The conversation is getting very interesting because now we're saying that under institutions you will have to play a very fundamental role with regards to the accountability process. Is represented here and issues are coming up. Either they're pointing a lot of fingers at you. No. I would like to recognize the presence of the Ghanaian victims. They're joining us from online, and before the end of the program they will be making a presentation. That is, they have a petition for the government and they would like to present that here. But now I would like to ask Mr. Liu. Them too far from the yeah. Yes. I can hear you clearly. Mr. Job, I have a two-part question for you. Good. So far, what we have seen in some of the trials that took place after the TRRC, NIA 9, Yankuba Toure. So, I want you to tell us from the National Human Rights taking us through. But we are interested in knowing what the interest of the National Human Rights Commission is, and take us through some of the position of the human in the Gambia.
Yeah, thank you very much for participating in the very important discussion. First, the National Human Rights Commission is very much interested in ensuring accountability for crimes that have been committed during the former regime. It was investigated by the court. It was a state responsibility that we all need to be aware of. The Gambia government has a responsibility to ensure that the acts that were committed during the review period, Dr. Tori, the brother of reality, and I think this is one of the passing of the special accountability mechanism and the special prosecutor's office. I think the role of the TRRC, which was not conclusive in terms of determining the evidence that is needed to further prosecute those individuals that need to be prosecuted because of the difference. So, in a nutshell, the National Human Rights Commission is very much in these accountability mechanisms are up and running. The second question regarding the issue of the death penalty and our involvement or engagement with the Ministry of Justice in the processes. The National Human Rights Commission has continuously played a very collaborative role with the Ministry of Justice in the entire process of the development of in a number of workshops that were organized to review and validate skills, and we have also provided input. So we are really out here with the content of the act, that is the two acts, and they are very, very progressive. Previously, consistently with our state of human rights from 2019 to date, catered for the abolition of the international protocol. The Gambia government has agreed to abolish the death penalty, or the first step towards abolishing the death penalty. So I think it is likely that education to look at the penalty. It's been abolished. This bill that is for the National Assembly, all the offenses that attach death means like the prisoner. So if those bills actually is passed into court, we will not be trouble with just the death. And so they, obviously, because the constitutional division is under the court of the Gambia, the front hand of the Gambia. Gambia law or Gambian law will apply. Under our laws currently, the maximum penalty for certain offense is going to try those serious offenses, for example, offenses of enforced disappearance, offenses of maybe crimes against humanity, so on and so forth. So it will be very ironical for a person receiving a death sentence or the life imprisonment. But I think these are some of the nuances that we need to be. I think that authorities will get the commonplace that will be afforded by the control. So that the justice will not only become, but it has already mentioned that counsel from Nala, that they as much as some of these people are charged or are asked to have committed very serious offenses, they also have the right to ensure that access, which is fair, is given to them, so that at the end of the day, we are able to deliver and make cases with respect to the never that human rights violations are perpetrated. It's a proceedings of application of the death penalty, and it is effective in terms of ensuring that we get the accountability that we want. That authorizes the death penalty. Some states will be reluctant, but that will be in violation of the statute. So no smooth drive, but at least it will be clear the way ahead for most of the perpetrators that are outside the jurisdiction of the Gambia. So it's a good step that we have the ability for the national family, right? Because otherwise that is going to serve as a hindrance. I think it's our view that the country should really do away with the death penalty, because of the very many reasons that are going to be given by doing.
On Mr. Joe's question. Now, the first time we had international criminal tribunals was the IMT. That was the International Military Tribunal set up after the Second World War, the Nuremberg trials, right? And we must understand this was in during those trials we had death penalties. 12 of the people indicted, right, is going to have primacy over domestic courts, and international law doesn't allow the death penalty. My question to you is, how do we reconcile that with what happened with the NIA 9 and the Yankuba Ture case? These people are sentenced to death, and there are people who have committed bigger crimes than them, and they're supervision at the High Court or before the hybrid court, and they cannot be handed the death penalty. I understand that there's a people a death sentence, and then trying other people like Yahya Jammeh and other people, and they won't be handed the death penalty. How do we reconcile these two? That is my question.
It's a very powerful question. I don't know what I should talk about. I was doing a training in prison in 2021 or thereabout. And by the time I left prison, the those on a death row. Blue are those on life imprisonment. Now, when I was very anxious when I heard about Yankuba Toure's case, so I knew that in court you have the moratorium is actually applicable in practice, but in our books, it states that the death sentence. I think the challenge we have, personally, after he realizes that other perpetrators are given 30 years in prison. But the law is what the law is. Yankuba Toure's case is technically closed in the Gambia, in my opinion. The court that the government should fast track the process on taking away the death sentence as part of our law, so that in the event where in the event where it is given consideration, like we know about the Yankuba Sonko's case. The Yankuba Sonko is being tried in Switzerland. And we ask ourselves, why Switzerland? Why can't we try in the Gambia? Osman Sonko is being tried in Switzerland. And others as well, because they will always link to the fact that our legal system has, for example, crimes that attract a death warrant with our hybrid court. The hybrid court is a special court with a special dispensation. The implication is that preoccupation again is that people need to be properly educated. You know, TRRC played a role that is kind of cool. How would they take it to realize that our special court deserves the offenses with which they are turning trial? So we should brace ourselves. So we know that now when it's a court, it's an entire ball game. They can go to court and choose to be silent. What will happen is that they will have to prove the case against them and the incoming people that a trial process is a complex scenario altogether. Nala is here, so that we don't also start getting angry with lawyers for defending people we consider as, you can see how can the former bar president of all stand to defend, knowing that accountability in itself is a whole process, and the trial process is now determined by law. And when it comes to court and we realize there's no evidence, we may get angry. So let's brace ourselves for our trial process and expect anything. I hope I'm not talking out of context. Thank you.
Good job.
That was a brilliant answer, Your Worship. And you know, you used the court, and we can prove a case against them, and we have to let them go. Now, I just want to give some historical context on this. The ICTR, the International Criminal Tribunal for Rwanda, indicted 93 people and secured over 225,000 people in the prisons. All of these people could not be tried. In fact, they could not be held in the prisons, which is why they brought back the Gashasha courts. These are traditional court systems. But these Gashasha courts have no form of punishment. If somebody confessed to killing and they admitted to it, they go through a traditional process. There was nothing like a death sentence. And what that did, Sal, was there was a lot of revenge killing in Rwanda. That is, these people that escaped justice, remember, there were only 2 recommendations from the TRRC that were rejected from the government. And one of them was the recommendation for amnesty for Sana Sabali, right? Because
first of all, I think it is important to note that not all perpetrators will be prosecuted. That doesn't happen anywhere. In as much as it is hard, they only prosecuted by black people.
yes,
I mean, yeah. I mean, so international tribunals tend to prosecute the leaders, and also those who perform who did the most serious crimes, like killing people and stuff like that. And like my friend has said, the court decides guilt based on evidence and law. It's not necessarily crimes. They're not even bound to. Even whoever is recommended for prosecution in the white paper, they're not necessarily bound to follow that. It just says that for crimes committed between 1994 to 2017. So their mandate is to look at evidence and be able to prosecute people within that period, not outside the period. So it means that, and of course they have to be based on evidence, because as you know, the people can go to TRRC and say that and retract. It has happened in Rwanda. They may retract what they said in the commission. It happens. They may retract it happened in the local case in the ICC. Yeah, they may go and say, well, what we said, we were under duress or we were under pressure. And also, people who went to PRC did not have the benefit of counsel. Counsel did not cross-examine. People were accused of doing certain things on television, on radio, on internet, and they didn't have the benefit of even cross-examining those who are accusing them, which cannot happen in a court. So the court is a completely different environment where the accused persons will accord their due process rights, like both my lawyer friends have said here. They will accord, in fact, the mechanism will have services that will ensure that people who are accused are entitled to legal defense. In all of these kind of courts, you have access to legal defense, whether it's NALA or private bar. That service is envisaged, and it will happen. So we need to manage expectations, because I think part of managing expectations for victims is we have to look at also the process of trying to get to what the process was. The process. We went through the process of getting to the truth. Now, the justice process, you also have to also follow the due process to establish whether or not somebody is found guilty or not guilty. If somebody who may, in the court of public opinion, is guilty, may be found not guilty in the court of law. For example, many victims are unhappy that certain, let's say, adversely mentioned persons who were detained for a while were released, and there was an outcry. But we part of the procedure process is ensuring that we respect the rule of law. So the Minister of Justice, the government, had to release it, because you cannot detain someone without any legal basis. As painful as it is for even me personally and for the victims, as a lawyer, I have to say, well, if you're talking to people, human rights applies to everyone, even accused persons. So it's a very delicate subject, a very tricky subject, because we don't have agency to be in the victim's shoes, because what they feel, that we don't feel it. But we need to also help manage expectations and involve the victims so they understand why, how it happened. That it didn't happen arbitrarily. It happened because it's the law that says so. So there will be in our eyes are guilty, but the court might acquit them. And sometimes there are people who may enter into plea deals with the prosecutor and be prosecuted for a lesser crime to help them get a bigger fish. And somebody you think should be locked up eternity may get a low offense, but may have get maybe a bigger fish. This like happens in all these kind of cases. So I think we need to have more engagement to explain the process to the victims and the country at large. As far as amnesty is concerned, international criminal law really doesn't recognize amnesty. That is not the prevailing thought. Because, for example, you cannot have amnesty for crimes against humanity. You cannot have, if somebody commits crimes against humanity, it may be a policy, but if you look at the jurisprudence of criminal law, because you cannot, the court really frown upon granting amnesty. So, of course, practical purposes to be able to convict certain kinds of perpetrators, the prosecutor will have the discretion to enter into plea deals where they ideally it will best to force charge them with a law offense and get them convicted first before they give evidence, so that at least you cannot say that the evidence is not they're not motivated by, because they've already been convicted, so they cannot be motivated by what will they get. So that is the practice that has happened in international practice. But I think in terms of amnesty, it's a tricky one, but it is not.
Yes, yeah. Sam said he has a comment.
Thank you very much. Just a few comments to add to what was said by Your Worship and Senior, and to clarify certain concepts of the TRRC was not to recommend particular alleged perpetrators for prosecution. from the word itself, TRRC, truth, reconciliation, reparation. Reconciliation is one of its primary tenets. Because the community has been divided by what has happened, and people are in pain, there is a need for the community to come back together as one through a process of reconciliation. So if certain people are not even prosecuted because they have reconciled themselves with the community, they have been forgiven by the victim for what happened, for minor offenses, the community will live as one. It is better you reconcile with your neighbor and you live in peace than to have your neighbor in marital prisons so that you can say you have won because you have been prosecuted, convicted, and sentenced. It's a difficult thing to ensure that there is reconciliation because we have to live together in society. There must be no animosity. But for the bigger offenses, it is true that justice can only prevail when someone is punished for some kind of crimes. That's the first thing I wanted to make clear. The second thing I wanted to make clear is my brother talked about
with convictions. I'm saying they did not have a traditional punishments like death sentence, life imprisonment.
It is true there were no formal cases like this. Just under trees like we see in the Bantabas, conciliation, and there were no prosecution. Together with your neighbors. We are human beings. We are social beings. Can you live without your neighbor? But then understand that it's guilty of any offense as we speak. None of them. Whatever happened at the TRC ended with recommendations that the government can do, not that the government must do. And as my learners see and see whether it has enough evidence to be able to prosecute them.
Killings. They led to revenge killings. That is, people who came in front of the Gashasha courts and then they were left to go home. Other members of the society went after them and killed them. And if you guaranteed perpetrators that if they come in front of the commission and confess and admitted to doing everything they did, the role they played in apartheid, they will be let to go scot-free. Do you understand? Why do you think the EFF is so popular? It's because most of the land, most of the property, everything is. When we talk about the issue of reconciliation in the Gambia, reconciliation must be something that both victims, perpetrators, and individuals voluntarily engage in, a sort of the security that if somebody breaks the law, they must face the consequences of doing that. Which is why reconciliation will have a continuing set of crimes. That is one. Two, the people recommended for prosecution is not such a long list that we cannot get through it. That is two. But there are challenges, and that is my question to you. What are the expected challenges? Because one of the biggest challenges we had, they had in the ICTY in Yugoslavia was that some of the people that even came before the Quran were, and when you get on social media right now, you still have people saying all the problems happening in Gambia will not happen. I'm so happy that the hybrid, some of these recommendations are going to be faced.
Thank you very much. I absolutely adore how everybody is now really fixated and really listening intensely, and with a really great initiative. And I really hope that we can look into making a curriculum at the University of the Gambia or elsewhere on transitional justice, because it's not a conversation that you can unfortunately have in a day, and definitely not in 2 hours. I've heard so many different aspects of unpack further, the difference between forgiveness and what does reconciliation mean, what forms does it take, what is more important, reparation. So I'm narrowing it down to just when we discuss the SAM, the Special Accountability Mechanism. And this was a policy decision by the government that when it comes to process, we are committing to them. And we're going to do so by creating the SAM, the Special Accountability Mechanism. So to come back to what will be the challenges for the SAM. Well, the first one I think has been articulated very well here. RRCB du court te message boobu noonu war nañ koo firi ko firiyaat ko ba waxtaan ko ba lawal ko because wax dëgga dafa set yenn expectations yi nga xam ne between lan mooy court ak lan mooy truth seeking process daf leen a disappoint mënuloo toog wax you know so TRRC mu nga toog ko ne maa ko dégg kii moom ma ko wax and everything is allowed and that's how it should be because truth seeking process la ñëpp lañ fa invite no matter sa state on the part of the government mënuñ koo def ñun keena kese dañ soxla civil society 1 billion% dañ soxla civil society pour yëfi communication bi dañ soxla nit ñi ci seen diggante ci seen cabinet ci seen néeg yi pour ngeen di waxtaan yi pour di firil each other dañ soxla a lot of help when it comes to communication bi ñëpp a war a communicate along the same lines pour ñu really understand xam nga lan mooy court process bi lu tax mun naa taxaw si kanami court bi ne man de xaw ma li ngeen am lan man waxuma loolu rek loolu rightam la si court you understand so communication is going to be very, very difficult and we're going to need lots of partnerships around that, particularly with civil society. Besides communication, capacity, technical capacity. This will be the first time that we see the nature of these cases being built, being investigated, being adjudicated, being prosecuted, being defended in the Gambia. We need a lot of capacity, a lot of capacity comes in trainings. I think my learned senior, you must be, one of the Nala training. Ministry of Justice, ñu ngi leen a train, judiciary bi ñu ngi leen a train, waaye ñu Nala training ñen. Okay, dégg la. Dañ soxla more trainings. Ñun ñëpp a soxla more trainings. Judiciary bi just everybody dañ soxla more trainings. Even civil society, bar bi dañ soxla more trainings. Activist. Because RC staff had, the media had. I think Tabora was the first time I met you in June 2018 at Ocean Bay. Ñun ñëpp a soxla trainings to understand what we're about to do here. Besides the trainings, we also need things. We need materials. And the best way maybe to hold them is within one complex where the accused persons, the detained persons, can easily travel from the detention center maybe to the court. And the offices are not very far away, so we need to build structures. That takes money as well, right? So we have capacity issues, technical capacity issues, material capacity issues as well, human resource as well. This comes back to communications. So far, we've been very used to Gambians doing most of these jobs with the TRC, with the CRC. We're very Gambian-led, and we continue to be with the Special Accountability Mechanism. Clearly, Sam is a Gambian, I'm a Gambian, and we're working on these issues. But the reality is we may not have enough lawyers, we may not have enough judges, we may not have enough staff, really, personnel in the Gambia, and we may need to rely on our brothers and sisters from the ECOWAS region, you know? So these are some of the capacity challenges that we're going to have. And of course we have the legal challenges. The legal challenges in first creating the laws that we don't have, but even after we create them, once the trials start, oh my day, financial resources. That's the next challenge. We have budgeted this whole process, but we are actively mobilizing the resources for that. Now, people give you resources, is that we are one government. Ministry of Justice Nala, unfortunately, he's left now, but we're one government. This is our joint project. We must speak with one voice. We have to jugo, right? Besides, when the partners are speaking to you, yes, of course, criticize and so on, but please, if you instill trust, so then we're Gambian si project bini, gis ngeen si sen boka, foog ngeen to be able to mobilize the resources, right? Because it's going to be an expensive venture. Once we start talking about an international tribunal, we're talking about international law, we're talking about international standards. Those people cannot go to mile 2. Because the moment they go to mile 2, the first day they see a judge, they'll say to the judge that my rights have been violated, I've been kept under terrible circumstances, and inhumane, the Mandela rules and all of that. And next thing you know, maybe you lose that case. So we have to build what is of international standard for those to ensure that they're in those conditions. So there's quite a lot of challenges, right? But I think a final message maybe, that we can overcome them. I truly and fully believe that. Not just for the SAM hearings 3 months into the commission. You're not going to be able to finalize the report. You're not going to. But we have. We really have. And I think that's the same kind of attitude, and we work at being a voice. Criticize when it comes to mobilizing resources. Joxe this message si project bi mun nañ ko def dimbale leen ñu si, and we will make sure that it happens.
Thank you very much, Aida. I think it was the representative of the Ghanaian victims joining us online. You have a presentation to make.
Please, can you hear me?
Yes, we can hear you, Mr. Mensah.
Thank you very much. My name is Dr. Mensah Emmanuel Geshin, representing the Ghanaian victims. And for the new victims right here, we thank you once again for the opportunity offered us this morning. And also want to this opportunity thank the government of India, Minister of Justice, and the team and the National Assembly for passing this watching. I took part and watched the proceedings. And I remember I had one or rep saying that Gambians don't want development and Gambians want all. Interesting. I said, well, when the country has peace, that is the greatest development that a country would have, in my view. So this project, by establishing the TRC ahead, open the bills to be passed by the time is a great opportunity. Gambia, you are leading. Some of us are. You are observing and we appreciate you very much. Regime. And apart from TRC inviting us to come and give our testimony or testimonies, we haven't gotten any communication from the government so as the implementation of the TRC recommendations are concerned. We were promised in the recommendation, it was that some reparations came to us, some amount of money. Up to now, we haven't heard anything from the government. We were also told that the bodies of our dead family will be exhumed and be given back to the families. We haven't heard anything from that. Again, he said there will be some kind of psychological treatments or advice or counseling for the victims that maybe the Gambian government has communicated to us A, B, or C. And so therefore, this information you need to hear. This is our case this afternoon. We thank you very much for the opportunity once again.
Thank you, Mr. Man. Process, and we were all here listening. So the floor is open. If you have any question you would like to ask to the people on the high table, or if you have any contribution you would like to make.
Huawei. This one has fully fallen down.
Wah yi ñoo wax ni fii sa néebo bi la reyal nga dëkk ak moom ba bu set nga di ko gis muy def loo xam ne du la naxari depuis Amitié high school ba fii mu dee nga ñëw instead of nga jaale ma nga ñëw naan d'état man ban coup d'état rek laa ko wax rek ma rongoo ñi di doon may jooy coup d'état boo xam ne amuloo fetel amuloo paaka ay lii wax yi nga wax mu ne ma ne ko foogoon naa ko ci beneen gémmiñ bu dul yow waaye nag àddina moom daf dee dox ñuy dox di dem ba ci kanam la daloon ñële ñëw dal ko te fekk na moom poste bi mu handul at that moment moo ëpp a ñële seen bos lifiñ ko yóbbu ko mile 2 ak yooyu ba after 17 years ñu soog koo discharge mu dem so yow ku mel ñu mel noonu nga ne dëkkandoor boobu jaruta seet ndax dëkkandoor boobu mu ngi lay ñaawal every day nga di ko gis mu ngee def lu la naxari saa yu nekk ngay ko gis wan la neneen ne lii man maa ko def voilà waaye suñ lii yii ñoo wax suñ demee ba dugga ci seen noppay loolu mooy rek pareel nañ ñu taxaw di ñu xaar parce que saa yu yii nii lii online la saa yii dafa tax ñu gën daal anyway dama discourage torop sax torop waaye nag yàlla jeexut yàlla bi fi nekkoon ba tey moo fi nekka ñu ko ñaan rek di ñaan ci suñ borom ne perpetrators si yal nañu yàlla àtte ak ñoom ak si nu mu gën a gaawee waaye neexuta muñ pour nga dëkk ak nit ki mu di la tooñ
maa ngi nuyu ñëpp di nuyu ñu nekk si high table bi andi yow maa ngi laa gërëm bu baax sa
xam nañ ne bi ñoo gaañu benn Gambian moo si bokka man may jabaram maa ngi biiroon 7 months waaye saa yuñ ma ooyee ma dem su ñoo wax Ghanaian duñ wax 81 Gambian loolu jaaxal na ma torop te discourage loo na ma torop te du mun a génn ci suma xol bi lan moo tax Ghanaian yi nga xam ne nekkuñ fii always saa yuñ ma ooyee programme dinañ wax seen affaire te duñu wax 81 Gambian man loolu moo ma jaaxal torop ci suma oote bi te tayal loo na ma te discourage na depuis 2005 ba léegi lacce ndax Lamin bokkut ci ñooñu te ñu ne Lamin mooy woon seen agent te Lamin jëlee nañ ko xool nañ ko génn na suma néeg isiwaat nañ ko suma biir néeg def nañ ko liñ koo def ba saa si yàlla tey bii depuis 2005 ba léegi gisuma niw dégguma niw.
What I've really gone through, because killing my brother make me to be a school dropout. We are the only 2 male siblings of our family. So I was preparing for my paid my school fees before paying my exam fee. This trial started. Many people are going to be disappointed. I've never been disappointed of the Gambian constitution. You see, my brother, they killed him, and it's Sada Sabal and these people who killed him. We all had the revelation at TRRC. What Sada Sabal said and what Edward said. The evidence are there. They exhumed their bodies. Their remains are still at RVH. So still, he can again go to the court and again say that all the revelation that I made was a pressure on me. Where are they taking me, or maybe me and my family? Where are we going to head? Where are we heading? This is a million, because my brother, who knows him, even in the army, before joining to army, he was at Radio Gambia. He was the guy who was doing news in English at 10 o'clock. From there, he went to School of Nursing. He did nursing to defend the country.
Well, good afternoon here. I am Ibrahim. Find facts or to go in for reconciliation, but also to reparate the victims as well. I am not denying, like saying that, well, we should not engage ourselves into tit to a tit, or an eye for an eye. Like, we can just go in for, we cannot punish the perpetrators for the crimes they have made, because we all know that, like, for us to prove or to convict someone of a criminal act, like the person or the prosecutors need to prove that I sustain this thing, because they said they accuse me of witchcraft, being a witch, and nothing was done to his foot. And he said that, well, and that is the same thing that look at the victims as well. Let's give them psychosocial support. Like we cannot just leave them like that. So this recommendation goes to the Commission and Ministry of Justice. Let us go back to these people. Let's consider them. There have been, like every day, some of them will be telling us on them first before going to the perpetrators. The perpetrators have made their submission. Well, if we can convince them to forgive them, tell them that you need to forgive these people without giving them reasons to forgive them. I myself, if you kill my father and said that I should forgive the perpetrators, or the perpetrators met with that order.
Good morning from Kermot Ali. You may have community in Kermot Ali, in Upper Salem, that was booted out from their forefathers' land and then forced into exile from 2009 to date. So this community at the time numbered 81 compounds, and in the province most of the families are extended families. Imagine the entire 81 families since 2009 living in Senegal in a forced exile. The Gambia government disowned them. This Gambia government also neglected them, have not created any opportunity. 2017, when the government of Yahya Jammeh was defeated, we went to court by suing the current government, and we had a judgment in our favor. The court decided in our favor, declared that we are Gambians, and we have right to return to the country and take back our properties. And the funniest part of it is when we leave our community, other people were given our residence, our own built home. So until today, our homes in Kermot Ali that we abandoned have been given to other people, and they were being given to the other people by the government of the Gambia, and they continue to enjoy that support until today. So during the incident that led to our forceful eviction from the Gambia, a lot of right violations had happened. Various kind of right violations had happened. Until today, the government of the Gambia has never shown any solidarity with us, neither does it. That these are Gambian people, they are my people, they are the people I have the responsibility to protect. I have the responsibility to provide every aspect of social amenities like I am providing it to other part of in every part of the Gambia. Imagine from 2009 to date, no social amenity. Government of the Gambia cannot claim any aspect of development provided to us. In fact, what had happened is they constantly made persecution against our people and also deny pregnant women access to health. Students, children have been denied access to education. From 2009 until last year, no single child from my community had ever had access to education until the intervention of Women Association for Victim Empowerment. This is a gross human rights violation. And the issues of Kermot Ali, what had happened to Kermot Ali, appears to be genocide, because it is an entire population that have been forcefully expelled, and they are expelled on account of just religious difference. It is our only crime is having our own religion, believing differently with others, having a different belief. It is not wrong to be different. So I think government of the government needs to take its responsibility to correct the wrongs in Kermot Ali. It is very rare, or I have never had in any meeting, any platform, where government, through the Ministry of Justice, would mention Kermot Ali. Imagine an implementation plan was issued May, if I am right, 2022. Yes. Now, until today, you can see on the implementation plan, there are a timeline indicated for every activity. If you review the implementation plan, you will realize that there are shortfalls, there are some activities that are behind the timeline. So should we go on like that, and the ministry or the government tend to think that they are convincing the victim, or they want the victim to have trust on the implementation of the TRRC recommendation, because timeline or an action plan is a strategy that you are using to implement. So if you are falling behind on what you plan, there is always a difficulty to prove, to earn the trust and confidence of the people that at the end of the day you are going to offer justice. Aside from that, SPO and the SAM have already been passed. Now I would like to know how soon would these offices be established. And one important thing I observed, there is popularization of the accountability for the Jammeh atrocities and those who associated with all those actions. But there is no popularization on the need to preserve what could be used as evidence against these perpetrators. We can all learn from what has happened to the NIA when the TRRC visited there. There was a concealment of evidence. And until today, if there is popularization of holding Jammeh and those that bear the highest responsibility to justice, that is widely known, and that popularization is achieving its objective. But there is no more early. During that incident, the PIU officers would come to a particular compound, lock the compound, and they would surround the compound. Nobody will be out in that compound. There are a lot of things that have happened there, and until today, other people have been taken and given those compounds. Where is the preservation of evidence? Where is the seriousness of government in holding perpetrators to account? So there are a lot of things that needs to be done. For me, I think there is two most important things that government through the Ministry of Justice that is implementing the TRRC recommendation lack. One thing is there needs to be an improved communication between MOJ and the victim, and that is quite lacking. And the other thing is there also has to be open and frank discussion between actually what the victims are living with and what is supposed to be done for them. Imagine for the issue of Kermot Ali, everything that has been stipulated in the implementation plan, I could not remember anywhere where any single member of Kermot Ali was consulted. How can you decide to compensate, or how can you decide to bring justice for a particular entire community at a time when you are making an implementation plan without involving any member of that community? To me, there's a lot of things that needs to be done. Thank you very much for your attention, and thank you for the organizers of this event.
Anybody else or answer? There's been a lot of... She has?
We actually have Madi's question online.
Okay.
Yeah, we have Madi.
Can read that out.
Okay.
Yeah, so Madi has a couple of questions. I am sure this one goes to Ida. The first question is asking, Madi wants to know what is the timeline, when are these institutions going to be in place and when are they going to begin operation? That is his first question. Another question he mentioned is that, the poor prisons, the poor condition of the prisons that we have, is there a plan to address that issue within this mechanism? Ida. Okay. Ajam, you have a question, right? All right. Here we go.
Good afternoon, everyone. My name is Ajam Muhammad. I'm a final year student. This is a concern raised during our last session by a victim who said that they were particular about the duration of limiting the duration from the 1994 to 2017 persecution, and not the 2017, the political impasse period. She said she was particular about it, so she wanted to at least have a clue why they limited it from that duration. And that was the only thing. She said we should relay it when our next session. Thank you.
All right. Thank you very much for all the questions, and you had said that we should be engaging in open and frank conversations. Then what the waktan di wahante diga, you know, di wahante diga bisuna haresa. Then what di wahante diga, right? The conversation is one of those things. Mawalen every single time event the victims in bolongin new government. Last week, Mam de Yona, week before Lulu, Sapinyang Yona. Next week, you get them memory house. Why every single time, si why better in Yungsi? If for none they party when a Gambia de Kabundaula. Do the victims and body, government and glory. Government needs la. I need a paneka, Ma paneka, Kenena paneka. Victims, you see government. Family members are victims. You see government. So wholly government is as a civil service. Nyom tamit. Amning sel own violations. 1, 2 nunela economic crimes. Who talks in class togulo wirulo. Sometimes then they create this divide that isn't there. But nonetheless, lingenawa digala. Nonetheless, yen len gina toy yena gina sofa yaga ngeen di mun nonetheless lolu mom ken munu ko gene from yen. So anything you have to say no len ko muna wahe you ko cho ko sanga ko betay dinañ len deg. That's the first thing that I want to say. Questions si bari nañ ma ngi try to remember everything ak naka la ko tonto, but for na for chill a step back. Mr. Silla, I don't know who that person is yet. The mom, moy am officer, mom moy def the determination. Can la mo charge, lan la po charge, luta mu charge kili, luta mu dem into plea agreement pour ki mu joko information pour no ñun ñep ñu fi tok yep we're just speculating. Dañoo speculate rek te it dañ see yokka ñun suñ own experience. Bala ma ñëw Gambia di liggéey si fi TJ lawyer laa woon si international tribunal si liggéey naa Rwanda liggéey naa Yugoslavia te man lu tax ma decide ne transitional justice laa bugg a duga yëfi truth seeking laa bugg a duga because xamoon naa ne court si at the end of the day dafa des luñ mënoon a defal victims dañ des lan lañ mënoon a def but maybe suñ si aadoon reparations. Even you also amutoon case at the end of the day, but num bon am the reparations, maybe loolu tane na, you know. So man luñ fi wax yep about that all this evidence, please let me take that back. I did not say, we don't mean to say that there will not be a case, based on your brother's murder. I didn't say that. I don't mean that. How must the case become in Nakalamo? At the end of the day, then they disappoint a lot of victims. Because then they select yan lenyo yobu and all these other considerations. So they may know what the court will ask you, evidence thresholds and so on. Generally speaking, then you frank conversations. We have to tell you in advance. Generally speaking, victims when they are satisfied, see yefi trials, yefi prosecutions. Tell luma si they meeting more in a free Gambia. So larger population with prosecutions is very important to us. Go ahead. We've done so many surveys. Te nit ñi dañ bëgg prosecutions te man ragal naa ne at the end of the day maybe du foofu ngeen a gën a amee seen mbégte loolu moo tax suba guddee bëccëg maa ngi ñaxa di tooy si yëfi reparations yëfi law reforms yëfi other things because all of those things together perhaps si benn one of those issues victims can find other forms of satisfaction, you know. They're gonna some comments about how reparations is very important. There was a law student. I can't disagree with anything on that. It certainly is very, very important. Lolu mota, the TRRC, unlike Yenen Truth Commission, Yenen Dika, they len wahne till len $1 million door len the reparations. Problem with reparations, mawala lan moy problem with reparations. Amuin halis enough. Immediately, right now, could solve all the reparative problems. We went to see His Excellency the President, Mr. Silla, you were there. Explain na ko, Gambia, just Gambia as a dika, do they make enough halis could solve some problems here? Flex dan, yo reporter nga, farmers yang fi, you know, ferry bang fi, schools in move fi, healthcare move fi. Hamga, just generally to mobilize it. And the people that have been helping us the most to do all of this work, the TRRC that you saw, the CRC, all of this are partners. Operations. Then we have Lulu Motamaro one, maybe swing Guinea di Watan and have the same messages. Maybe we'll be able that medical reparations, school fees, building of facilities, we need reparations. They saw la more halis, he kneeling for them and we're affected. Why tahu deng they know better? Because li moy swing role, li moy swing responsibility. Better dineng book dinyo, better dineng den book dinyo. On Kermot Ali, I'm very sorry that you're expressing the concern to me. What happened there. What definitely implementation plan B was hope so. So recommendations from TRRCB, that's what the government accepted, all of them. Everything are important. Everything is pressing. Everything has to be done now. You know, and we're a very small team and we have limited resources. So then they always try to prioritize, you know, maximum effort. Jabarin Lamin Tunkara. I'm sorry tamit ne do de diga turam to everybody ñu ngi ray bes bobu nonu bokana ci recommendation bi ne ñu prosecute for lolu nonu establishment of SPO bi lolu yep ci la boka SPO bi exhumations always limota a lot of my colleagues psychosocial support bi tamit ne reparations commission bi dañ wara joxe psychosocial support definitely mu fa tamit, you know. And lolu mota leneen la buga wax tamit moy ne gis nga so gisee all these partners civil society ñu mëna am funding di ñëw di def activities ngeen ne ñun wave moo ñu faale o aniket moo ñu faale o will moo ñu suñ ko binda suñ ko sign government ak sign Ministry of Justice la jaar ñun xam nañ lan la civil society bi di def ñu ngi liggéey ak partners yi pour ñuy joxe xaalis pour civil society def activities yi. It's not possible pour USAID ñëw def fi project the government of the Gambia approve ko. So you know maybe tamit ci communication bi it's definitely a priority, you know. Te luma de also wa every single time ma am opportunity pour meet victims is pour wax leen ne ngeen organise seen boppa Ghanaian victims yi ñu ngi depuis bu ma dooree government am nañ WhatsApp group every month dañ dee am dinañ di am these on a local level. Man yàggul suma cousin dañ jël paaka jam loxoom mi clip karab nañ dem nañ police evidence fii amuñ fii in the end case bi demul fenn daf di mën a xew on an individual level astuma case bi nga xam ne happened a long time out, you know. But more importantly, you know, ñun nekkuñ di decide loolu noonu. I don't want you to leave here to ne da ngeen discourage because doo leen amee ci case. That would be very wrong su nekkee ne message boobu noonu lay start as quickly as possible. te foog naa tamit National Assembly bi dégg nañ loolu moo tax bu Reparations Commission bi ñëwee si ñoom ñu pass ko immediately. Bu Special Prosecutor's Office bi ñëwee ñu pass ko immediately, you know. So for now, all arms of government, whether you quick remark to say, please work with the Gambian victim-led organizations. I think you work very closely with WAVE. Please continue to do so because it is through these organizations as well. The Reparations Commission will be issuing reparations to all victims regardless of nationality, and we're working expeditiously to select the commissioners of that commission. So the work definitely is ongoing. It's definitely a challenge, but we're hoping that it improves as more victim-led organizations. But I look forward to the petition and looking further into detail into it.
Yeah, we are already behind time. Yeah, so Mohammed, let's have the petition presented and then we can wrap this up.
Are you just going to hand it over to me? Okay, thank you.
I think they're doing a photo op, but I am.
Yeah. I see.
The first. You want to stand next to me?
Is this fine? Yes, I do.
And I'm glad we had Ida to clarify some of these issues. But this is a conversation we must continuously have. Each and every single one of us has a role to play in the entire process. Right? We keep talking about the Never Again campaign, the non-reoccurrence that we need, and collective roles to play. and we must all recognize that. And unless and until we all do in South Africa and how that is still affecting them as a country, right? We talked about some of the examples that we've also seen in Sierra Leone and Liberia so far. So we have come this far, we need to finish what we started. And even though we have concerns with regards to resources, with regards to human resources, with regards to financial resources, and some of the challenges that we are facing, start pushing from his end, I am pushing.
We write on social media. If you are a victim and you write what is derogatory, it's you. So when a victim gets up and writes, oh, I'm disgruntled, this country is bad, nothing is working, nothing is happening, the partners who are supposed to assist are written. So much as you personally have to benefit, ask yourself, you have a role to play so that this doesn't happen again in the Gambia. So, caution, let's be careful what we write. Thank you.
Thank you.
We have the, what is lacking?
Photo session.
Okay.
So let's prepare for the next.